Fifth Amendment privilege against self-incrimination. Any person in any proceeding, civil or criminal, may refuse to answer a question if her response might incriminate herself. Privilege only available if compelled testimony or communicative evidence is testimonial, verbal or otherwise communicative evidence. Lineup and physical evidence is not testimonial. Compelled is illicit or induced, so evidence produced from defendant's free will is not compelled. So the defendant's diary is not compelled. Lie detector tests, custodial interrogations are compelled, and Fifth Amendment privilege will apply. Does not apply to companies. A legal entity, a corporation, partnership, LLC has no Fifth Amendment privilege against self-incrimination. Exceptions. Privilege does not apply if 1. Grant of immunity. Governments can grant immunity from prosecution for self-incriminating testimony. Incrimination is not possible, so a statute of limitations has run. Or 3. Extinguished by a waiver. Defendant waives the privilege. So the exceptions to a privilege are the 3. 1. Grant of immunity. 2. Incrimination is not possible. And 3. Extinguished by waiver. Note, at trial, prosecution cannot comment on defendant's silence or failure to testify. Miranda rights. Those in custody must be informed of Miranda rights prior to interrogation, otherwise subsequent statements are inadmissible. Custodial interrogation is required. Miranda only applies when accused is in custodial, in custody and interrogated. So custody, accused reasonably believes they are not free to leave. Interrogation means statements by police are likely to elicit incriminating responses. So unsolicited statements are not protected. Note, routine questioning during a booking or probation interview is not considered interrogation. There is a public safety exception, so police may interrogate suspects without giving Miranda warnings if necessary for public safety. And this might happen if defendant has info about a bomb that could go off in public. Miranda warnings. Police must inform accused that he has 1, a right to remain silent. 2, anything said can be used against him. 3, he has the right to the presence of an attorney. And 4, one will be appointed if he cannot afford one. Substantial compliance and reading warnings is sufficient. Failure to give warnings implicates Fifth Amendment, not Sixth Amendment. An accused may terminate an interrogation at any time by invoking his right to remain silent or by requesting counsel. So invoking right to silence. Police must cease all questioning. Only accused can reinitiate dialogue. Police may resume questioning after a significant period concerning unrelated crimes, but defendant must be rewarned of Miranda rights. Invoking Fifth Amendment right to counsel. Once accused requests counsel unambiguously, police must cease all questioning on any topic. Note, different than the Sixth Amendment right to counsel, which is offense-specific and only attaches once charges are filed. If accused initiates communication, interrogation is allowed. Waiving Miranda rights. Valid Miranda waiver must be 1, knowingly, and 2, voluntarily made. Burden is on the prosecution to prove this by preponderance of evidence. 14th Amendment and confessions. To be admissible, the 14th Amendment Due Process Clause requires that confessions be voluntary. Voluntariness is assessed based on the totality of the circumstances, including suspect's age, mental and physical condition, education, and the duration, manner, and setting of the interrogation. Double jeopardy. Defendant cannot be retried for the same offense once jeopardy has attached. Arises when defendant is prosecuted with one crime and tried, then charged again based on the same offense. Same offense. Offenses are different if conviction for one offense requires proof of an element not included in the other offense. Lesser included offense. Once jeopardy attaches for the greater offense, defendant cannot be charged for the lesser included offense. Examples include same offense, so first offense requires proof of A, B, and C. Second offense requires proof of A and B. Second offense is barred. Different offenses. First offense requires A and B. Second offense requires A, C, and D. Exceptions. New evidence for greater offense becomes available. Defendant can be tried for battery and subsequently tried for homicide if the victim later dies from the battery. When jeopardy attaches. Start of trial generally required. Does not attach for charges or grand jury proceedings alone. Jury trial. Attaches once jury is impaneled and sworn in. Bench trial. Attaches once first witness is sworn in. Pleas. Attaches once court accepts a plea agreement. Once jeopardy has attached, retrial is still allowed if either A, there's a hung jury, B, mistrial due to manifest necessity. This is where defendant may be retried when there's manifest necessity to abort the original trial, or if it is discontinued at defendant's request on grounds not constituting an acquittal. C, retrial after a successful appeal by defendant. Defendant can be retried unless the basis for retrial was insufficient evidence to support a guilty verdict. D, defendant breaches a plea bargain agreement, or E, separate sovereigns. Defendant can be tried for the same crime in different states. Defendant can be tried for the same crime in federal and state court.